Hi, I'm Greg Dell with attorneys Dell and Schaefer, and attorney Stephen Jessup and I are going to discuss Hartford disability benefit claims today. And Steve, we've handled a lot of Hartford disability claims. Where do you see them in terms of a disability insurance company, how they act, and if you got a claim out of the 40 different disability insurance companies, how would you feel about it being Hartford?
Historically, Hartford's probably the most aggressive of the disability carriers I would see in their reviews. As we've had in videos and other things that we've discussed on their appeals process and all that, you see them more prone to independent medical evaluations, use of video surveillance, field interviews. So I would say they are definitely one of the more aggressive carriers out there.
Okay. So in this video, I want to kind of give an overview because like you just touched on, we have videos about applying for Hartford benefits, Hartford appeal benefits, lawsuits, and different tips and things like that. So some of this might be a little bit duplicative, but this is for someone who is just finding us, and I'd encourage you to look for other videos where we're generally speaking about Hartford as a company. Now, Hartford, I talk about different views with companies. There's companies that are kind of looking to find if you're disabled, and that's kind of like their culture and their view. And then there's other companies who are looking for a reason not to pay. So where do you put Hartford in that gamut?
I mean, they'd be leaning definitely towards the companies looking to not pay, as opposed to some of the companies that it almost seems they bend over backwards to find a reason to approve the claim.
Okay, I would agree with your analysis as well. I think it's because they're one of the bigger companies and they're so big, a lot of turnover with their employees, and they train the employees in a particular way, and the culture of the company is let's look for the reasons to not pay a claim. Now, what I also want to mention is that recently Hartford acquired Aetna. So everything that we're going to say here today applies to the Aetna disability policy as well, because anyone who has an Aetna policy, especially at this point, because it's been about 1.5 or 2 years since Hartford acquired Aetna, are all going to be Hartford policies. And we've had an opportunity to see how Hartford's going to administer the claims, and it seems like now everything has transitioned over and it's the Hartford way and not the way that Aetna did things. Would you agree with that?
I would agree. I'd agree. It's now purely, it's still say Aetna letterhead, stuff like that, but it's purely the Hartford way of doing business.
Okay, so when you get into a long-term disability claim, and we see a lot of short-term disability claim because Hartford writes a lot of those policies also, what are some of the most common reasons that you see for a claim denial? And the reason I bring that up first is because you have to look at what are the common reasons for a denial to be able to appropriately help a claimant apply for benefits.
Well, especially since you brought up short-term disability and starting the process early on, a lot of times people will, especially in short-term, apply for short-term disability before they've even really been into the doctor or the specialist if needs be. So that in and of itself is already set up. And unfortunately for people, if you need to get into a specialist for your condition, it can take a time to get that, that referral and get in. So that is one of the first things we start to see is that medical. Is the medical gelling with the reports, to why they can't do their job? So that's always first and foremost is the medical aspect, and that's what Hartford is going to look at. What's missing? And then even if you do have good records, this idea of if the doctor isn't specifically putting restrictions and limitations in the workplace, then they're going to say, well, if they're not there, that means there must not be a problem. So they're always trying to dissect your medical information to establish that your problem, yes, you may have the diagnosis, but it's not going to result in a disability under the policy.
Okay, so the most common definition of disability we usually see is either a 12 or 24 month definition of own occupation in Hartford, which says you're unable to perform the substantial material duties of your occupation. But it's not really your occupation, because what they say is your occupation is defined as how your job is performed in the national economy. So while you think you have a policy that's going to cover you for what you do in your job, it's really they're going to take your job title or the description of your job title from your employer, and they're going to come up with, basically from a dictionary of occupational titles, which is another source that they use through something called ONET, which is available on the internet, which was published by the Department of Labor, I believe. And they're going to just look at the physical task of your job in the national economy. So you need to be aware of that, because if your title is engineer, and you're in a very physical, demanding job where you have to lift things every day or you have to travel a lot, engineer is generally described as a sedentary type job where you're basically in front of a computer, and they're going to basically say, well, look, we know that your employer might have made you lift 50 pounds a day or go out on job sites or do evaluations or things like that, but it's not how it's done in the national economy, so we don't really have to look at how you did it like that. So that's something immediately that has to be evaluated, whether you're applying or appealing the claim, that has to be dug into. Talk about how we do our own custom attending physician statements and why those are important compared to the generic forms that Hartford presents to claimants.
With Hartford's claim forms, and this is common with insurance companies in this industry across the board, but Hartford, I think it's most common, or you see it the most, especially since they're going to try to strip down your job to the base physical demands of it. So in the questionnaires that they're going to send, a lot of times they're talking about, can a person do this occasionally, frequently? They don't really give the doctors an option to put less than occasional or less than 10 pounds of lifting, things like that. So they set the forms up kind of in a way that the doctors are thinking, well, my patient is very physically impaired. I'm going to do the lowest level. I'm going to check that. But a lot of times that can play right into what Hartford wants. And what Hartford is ultimately always going to do from a legal perspective is establish that they were giving you a reasonable review. So if they, whether you want to call it trick your doctors into helping them get to the point of a denial, they'll do that. So you have to be very, very cautious about the way information is presented to them. And a lot of times these forms are so generic and meant to cover so many different types of disabilities, it's really, a lot of the questions they ask may not be relevant to your medical condition. So you really have to kind of focus in on that the best as possible, especially early on.
Yeah, and you did remind me that in their standard form where it asks the doctor, are you limiting them to sedentary, light duty, they don't even have a category lower than sedentary.
Yeah.
So the idea is the doctor has to know to ignore that or not write anything, but often a doctor will write sedentary because it's the lowest choice. And that's basically just, that's a trap. Because now they're saying, oh, your doctor said you can do sedentary, when clearly that's not, that's not what the doctor meant. The other thing I want to talk about with Hartford is, how are they, what are these field interviews about? I mean, every day we get a call. Someone says, Hartford wants to come out and talk to me. And we've done videos about what you should expect and things like that, but what's really going on there, and why is Hartford one of the few companies that does that?
Well, the field interview is a way to put eyes on the insured. That's first and foremost it. Ever since the acquisition of Aetna, I've seen an uptick in them, and some of them aren't necessarily always the aggressive ones that you see, but predominantly, most of the time when a field interview is going to come, you may be approaching that change in definition from own occupation to any occupation. They've already got your claim forms, so they've looked if there's any inconsistencies. There stands a good chance they may have already done video surveillance. And during this field interview, they'll talk to you, can you do this, can you do that, can you do this, can you do that? And then they'll pull out the, well, we videotaped you and we saw you doing all these things. So they're trapping you in an official statement you're giving to them, not that you're lying, but you're not being forthcoming, if you will. So they use this field interview as a way to put eyes on you to see if you look as physically impaired. If you say your back hurts and you have a hard time sitting, if the thing goes for an hour, were you fidgeting? Did you ask to get up? Did you move around? So it's a way to also bolster this idea that they're giving you a reasonable review of your file before denying a case.
Right, and I think it's their classic technique for denying every disability claim that they're going to try to do this field interview first. And people call us all the time, and I believe you should be concerned if you get that call and not speak to them alone, because there's things that they're asking they probably shouldn't, and the people they're sending will go beyond what they know they're allowed to when you're not represented. So you need to be super cautious. I mean, I had a client just the other day who's been on claim for years, and I mean over 12 years. And what happens is Hartford gets a new claims person on the file who doesn't care much about the history, doesn't want to read 10, 12 years of medical history. This person actually sent the investigator to her doctor's office to ask questions, which is a complete HIPAA violation. I have no idea why they did that. The doctor's office called the client and said, why is there an investigator here asking me questions and wanting to show me video? So that was an extremely aggressive, technique by Hartford. We immediately contacted Hartford and said, what are you doing? To which the claim rep said, no, I didn't ask them to do that. But it was a horrible experience for the claimant, and it was obvious that Hartford was trying to do whatever they could to try to deny this particular claim.
And in that situation, they're even impacting the relationship with the doctor, because now the doctor may, put something in the back of their mind as something going on here. So it's a way to even undermine the doctor-patient relationship.
Now, Hartford is one of those companies when it comes to filing a lawsuit for the denial. You have your appeal. After you file your appeal, if you lose the appeal, the only remedy remaining is to file a lawsuit. And we've filed tons of lawsuits, hundreds, against Hartford for long-term disability denial. And they're one of the companies that has a ton of litigation out there all over the country, not just us, but other people that have filed. What is your experience like once you file a lawsuit against them? How hard are they fighting, and what's that process like?
Well, just like every carrier, they're going to fight. The law, unfortunately, throughout most parts of the country is in their favor. Going into litigation after that final denial, no new information comes into the record. So there's no jury. A federal judge is going to review your case. He's not going to hear from you, hear from any of your doctors. It's going to be just that moment in time. That's your claim file. And Hartford's attorneys, and they hire really well-known, good defense firms, large national firms to handle their cases, who've argued lots of motions, won a lot, and they basically set it forth. Here's what we had to do under the law. We've done X, Y, and Z. This is why we think we're going to win the case. So they're going to come with that air of, we feel that we'll win this, and even if we don't, we'll appeal it. We'll drag it out as long as we need to, because remember, their pockets are a lot deeper than the insured's, so they'll drag that legal process out if they need to. So you can expect that they're going to hire top-notch defense attorneys who are going to put as much pressure as they did during the claims review process.
Right. I think the defense lawyers they hire are high-quality lawyers. However, I feel that the defense lawyers are just defending the case. They don't make the determinations on how much money is going to be given. But I would say overall, a lot of these cases resolve with a lump sum settlement offer. If we end up accepting your case, we believe that whether or not we think we'll get you back on claim, we think that we're going to get you some kind of settlement offer. But the reality is with Hartford is that compared to other companies, I find them to be relatively stingy with their offers as compared to other companies, because they have such a restrictive disability policy with the arbitrary and capricious clause, and they have so much history and experience in litigating these cases that the law favors them. And they're very well aware of that. And unless you're in one of these states where you can get to a de novo review, they feel very confident in their abilities to prove that they acted reasonably. And it's not a big threshold. It's not fair to claimants, but it's the way the law is. And I think Hartford, unlike some of the other companies, tends to take more advantage of that and is more cutthroat without any care for the claimant. We've had a lot of good success against Hartford, are able to battle them and present all the things. But from my standpoint, I see the same type of reviews all the time from Hartford when it comes to an appeal. That often I feel like they'll use an in-house doctor to review the claim. They'll most always, if they go outside, they're doing a paper review. They'll sometimes do an independent medical exam or a functional capacity exam, whereas that gives the client some opportunity to try to win the case. Has that been your experience as well in terms of how they go about doing their appeal reviews and what they give you as ammunition to fight in a lawsuit?
Generally, in the appeal reviews, yes, they're going to go to outside doctors. The likelihood of an independent medical evaluation is usually leading up to a denial or before the change in definition from own occupation to any occupation. They are known, in my opinion, more so than other companies, to do independent medical evaluations there. Which sometimes works in the favor of the insured, but if the doctor they send them to, and we always research, are they practitioners or do they do this for a living? That can set the case in motion for them to basically almost ensure a victory.
The other thing is we know that Hartford will, in undisputed claims, offer lump sum buyouts. Correct. And we've negotiated many of those. So if you are interested in a buyout or if you received a letter from them, that's something that we can do that's separate from a buyout that we're discussing as a possible resolution in a lawsuit. Now, with any of these claims, no matter what stage your claim is at, we're always going to provide you with a free initial consultation to review your claim. We help clients all over the country, no matter where you live. These cases, if they have to get litigated, are filed in federal court, and we'll often pick the court that we think is best, has the best law that's going to benefit you. most importantly, people always ask us, how do you charge for these things? And when you're on a fixed income, it's almost impossible for us to charge hourly for these types of things because the hours it's a lot of work for every single one of these claims, and it's just not affordable for someone on a fixed income to pay hourly. So we offer basically a contingency fee, which means we don't charge any fees or costs unless we make a recovery for your claim. So it's either a percentage of a lump sum settlement or a percentage of your past benefits and your future benefits. And a lot of times people say, well, why my future benefits as well? And the reason is that just getting you back on claim or getting your claim approved, they're going to evaluate your claim every month, month after month after month. And we have so many clients that call us after a year, 2, 3, 4, 10, and they get denied at random times. So it's all about keeping you on claim and protecting your claim. And if you let your guard down with these companies, especially Hartford, they're going to jump on that opportunity to cut you off. So no matter what stage you're at, no matter where you live, feel free to give Stephen a call or any of our disability lawyers. We'll talk to you right away. We're going to answer your call when you call, and we're going to let you know if we can help you. Thank you for considering us.